Are you going to get on or are you going to listen? All right. Is everybody here that we're expecting? Y'all are
Yes, I'm on here twice by accident.
Okay.
Let me make sure. Well, I'm trying to get rid of one.
The other one's not doing anything, so.
It's not.
All right. This is 003-2069-2020. It's Cecilia Lee and Luxian Sue versus Timoteo Akinadid and Falashade Akinadid. I'm sure I botched all those names. And it's a motion to strike, and I'm not sure what you're wanting struck. I kind of think this would be better handled as a motion limine, but it
Well,
looks like there's a miscarriage that can be or can't be attributed to this car wreck. But I don't know if you're wanting it not to be mentioned at all, or how you want it.
Yes. And Judge, here's why I'm doing it now. I don't think it's appropriate to wait up until voir dire to have this issue addressed. Okay, because I think it's stalling any kind of moving forward. We went to mediation, and after being told that they were not attempting to bring in her miscarriage, then during mediation, they said they did want to. Okay. So I think we need some clarity on this issue, and sooner rather than later for everyone. And it is absolutely appropriate for a motion to strike. They don't have this lady is 6 weeks pregnant at the time of the accident. Right. She miscarries about 10 days later. It's mentioned in passing in some medical records. And when I took her deposition, she said she personally felt it was related to the accident. I said, there's no proof of this. There's no expert evidence showing it is. Has any doctor told you this? No, and I haven't been provided, and I've asked multiple times to be provided with any evidence from an expert that this issue is related to a motor vehicle accident. And this is not something that some layperson can just state would be. And so we got our own expert to review the records, and it became very clear that it was not, in fact, all the evidence shows it's not related to the accident. She has a long history of abortions or miscarriage before and after the accident. And at this point, I filed a motion to strike saying, look, there's no evidence from the plaintiffs that this incidental issue of her being 6 weeks pregnant, miscarrying 10 days later is in fact related to a motor vehicle accident. I've been provided nothing that causally ties and correlates this claim to a motor vehicle accident. It is not something that an average layperson could easily state would be true. As a matter of fact, it is not, clearly not. That the evidence we have shows that it is not, just so we're all very clear on this. And it's highly sympathetic. So if we put it in, it will be prejudicial without being probative to any claim she can actually prove is causally connected or correlated to a car wreck. And that's essential. And so that's what we don't want, is this brought up as a sympathetic sort of plea for sympathy or a claim without any kind of underpinning whatsoever to show it's probative or causally connected to a claim she can make. The response I got very recently yesterday just concedes there's no medical evidence to support that. They don't claim that there's any medical evidence saying that her miscarriage is causally connected or related in any way to a car wreck. There's no attempt to claim that. What they're saying is they still want her to get up and kind of say or have it in the records that she was pregnant and she was miscarried. And I was like, this is why we have motions to strike, and this is why we have these issues. You cannot sort of bring in on the sly or slyly bring in, well, I want to prejudicially talk about my losing a baby, and that was my concern, when it's not causally related and in fact didn't happen, and you can't claim it's from the car wreck because you've introduced this highly prejudicial issue and emotional issue without any probative support that it's a claim you can make in a car accident. And that's the essence. I mean, if you could do that, why would we even have Doebert challenges, and why would we even have limiting anybody's evidence and limiting it to something you can causally connect to a car wreck. It would be like saying, I was diagnosed with multiple sclerosis 10 days before the accident. And when I went into the ER, I was concerned that it would aggravate that, although it in fact did not. And there isn't any evidence that it ever did that. But I want to mention that to the jury and have them focus on my concern about something that's not related to the case.
What's the plaintiff's position on all this?
Your Honor, when I think first, I think the main issue here is that I don't believe that a motion to strike is appropriate at this juncture. One, I believe it's the plaintiff's obligation to prove what's in our live pleadings in our petition. At no point do we ever mention that essentially the miscarriage is caused by the accident. However, I think it's very important to note that contrary to what the defense is stating, that people miscarry after accidents all the time. It's very common. Matter of fact, when someone's pregnant and they get in an accident, what's the first thing they do?
That's
They go
not
to the
true.
hospital. That's exactly
That's not
true.
No, and there's no evidence of that.
Respectfully, it's my time to argue. I didn't say anything while you were talking. And I was pre-med. So, I mean, I'm looking at the records, even that the doctor provided. That's fine, but she can't even with 100% certainty say that this wasn't caused by that. You can say that there's no 100% certainty that the accident did cause it, but you can't say that the exact opposite.
Well, do you have any doctors that are going to testify that it was caused by this accident?
At this time, we don't, Your Honor. However, there was a doctor that was seen. She saw, she did see a doctor at some point that she has a Chinese herbalist that we're not sure if we're gonna add that, Your Honor, or not, just based on the difficulty of getting the records. But even at this point, Your Honor, we're not, even if the court was of the opinion of providing a limited instruction as it relates to mentioning the miscarriage being caused by the accident, I don't think plaintiff will have an issue with that. Our issue comes from essentially the fact that what defense counsel wants to do is prevent the plaintiff from talking about her state of being at the time. And I think it's pretty clear that at any point in any trial, a plaintiff and any person is able to describe their condition. And one of the points in mental anguish damages is being able to talk about your condition, is being able to talk about your state of mind at that time. You know, I think that's a valid concern, Your Honor.
It's about, the problem is if your client starts testifying that she had all this mental anguish, and then they could, I mean, I don't know, the defendant actually might want to, well, you also had a miscarriage, and that may be where the mental anguish came from. So I'm not sure how this helps either side, if that makes sense.
Well, honestly, Your Honor, I believe that, if based on what the defendant proposes and what they're putting out here, all of their evidence makes my plaintiff look bad. If anything, it's prejudicial for me. So,
that's what I was kind of thinking, but I don't, I mean,
I don't know that it's wise that she discuss her pregnancy if she wants to have dragged in all of her medical issues and claims. You've seen the report by Dr. Scott. Would that be a bad tactical decision? I agree. But you just heard opposing counsel admit they don't have any evidence her pregnancy or miscarriage is related to this accident. It is an emotional issue. It's highly prejudicial without in the least being probative. And to argue, well, I want to say that I had a concern about it means that you could entirely void the entire line of Doebert challenges and causal correlation challenges and bring in irrelevant stuff that isn't underpinned in any way as with probative evidence. It's in fact tied to any kind of claim or injury to a car accident based on your feeling. This is why you keep out prejudicial stuff that is not pinned by any causally related probative evidence that is in fact related to your car wreck. That's why we keep these things out.
well, so you have a motion to strike, and what you want stricken is what?
All reference to her being, I was pregnant and I had a miscarriage.
Okay.
And you can take 2 or 3 lines out of the ER, like 1 line out of the ER records and a line or 2 out of the medical. It doesn't affect her treatment in any way. It's not something that's so looped through all her medical records, it would be hard to do. I just don't want her to get up there and throw in, by the way, I was 6 weeks pregnant and I lost the baby, because there goes that whole opening that can of worms without, and they've just conceded it's not related.
And Your Honor, the end of the rebuttal is this big report that defense counsel has that says, well, you had all these miscarriages. So it wasn't related to it. Because the defense counsel comes right out and says it wasn't related to it. However, she doesn't know, neither does the doctor. But any juror can tell you, can look up there and say, oh, well, you have a doctor that says you've had these miscarriages, you've had this abortion, for the same reasons that defense counsel is arguing it. I think a jury should be able to look at that and believe it or disbelieve it.
I don't think a jury can argue a medical condition, and I don't think counsel can either. You just stated you don't need any evidence for a jury to believe something they don't have any proof for.
But again,
so that's the problem. This is not like falling off a ladder may lead to breaking your arm. This is something, and that case I gave right on point states this exactly. This is not something a jury can with common understanding. You keep saying that, but that isn't true, and you have no evidence for that. Not every car accident causes a miscarriage, particularly in a young fetus. We've made no effort to tie that in any way. You can't just argue it and say juries will understand that, because that's not true.
Well, I think it's going to be a cleaner trial if we do just not mention the miscarriage. And so I'm going to grant the motion to strike, which I'd actually want to call, we'll put it in a motion in limine, I guess, before the trial starts. Just don't mention the fact that a miscarriage occurred, and then we will redact any references to the miscarriage in the medical records. That way it'll be a cleaner trial, because I don't know who it would help more or hurt more, but we just need to keep it out.
It is messy. It's real messy. So do you want, I filed a proposed motion granting the motion to strike on the issues in the motion, which is her miscarriage. I can also send you an order renaming it. I don't quite know how you want me to do that.
I think the best way to, well, at some point, if we go to trial in the case, we'll have a motion in limine that basically says don't mention that she had a miscarriage.
I will surely add that. If you would, like you said,
then,
grant the motion to strike, and I will surely file a motion in limine that includes that.
Right, and then have a motion to, or in the order, mention the redact any mention of the miscarriage.
Okay.
Unless or until the plaintiffs can find a medical expert that's going to testify it actually was related to the car wreck, which
I would say they could always file a motion to rehear if they come up with it. So I'm just going to put in the order that if that's okay, I'll resend an order just so we're on the same page, saying you grant the motion to strike, that it will be mentioned in a board motion in limine before any trial, and just leave it at that. And then if they come up with new evidence, want to rehear it.
And
all right.
Okay.
Your Honor,
sounds good.
Thank you. Reference to miscarriage, pregnancy, or is it just miscarriage by itself?
Well, miscarriage and pregnancy are tied together. You can't say I was pregnant and leave it hanging.
They don't know whether she had a kid or had a baby. I mean, I don't.
Yeah, she had a baby. They're going to do the math, because she miscarried this baby, aborted another baby, then had a baby. So if anybody sits there, you know how jurors get redirected, and they start doing the math and find out the baby's 2 and go back, they're going to start. It's not relevant. She was pregnant and had a miscarriage.
All right. Anything else?
Okay.
Your Honor.
Thank you.
All right. Thank you all.
Thanks. Bye-bye.
Thank you, Your Honor.